Right, so let's start the meeting. If anybody, again, as usual, if anybody else indicates they want to get into the meeting, I'll let them in, and we'll take it from there. Okay, so first things with respect to roll call, I do have regrets from Stefan, Sean, and Andrea. So we'll record those regrets and thank them for that. Approval of the agenda. So it went out on Friday. Hopefully everybody's had a chance to take a look at it. We have before us today. Can I have a mover to adopt the agenda as presented?
Move unanimous consent.
Okay, all right, that's fine. We'll accept that. So thanks, Matthew. Okay, and next we have the minutes prepared for our last meeting. Again, it's a stellar presentation by Peter. Great minutes. So can I again have a mover and a seconder for those minutes? Howard,
I can move.
Thank you. And Brendan, thank you, seconder. All in favor? Carried. Thank you very much. Okay, so let's go to news announcements and updates. This is what I collected since our last meeting. The first one, obviously, is the Emergencies Act, which was an incredibly important piece of legislation that was invoked since our last meeting. So I have a couple of links there in the agenda. I have the link to the act itself, and then there was a link to a Toronto Star article with respect to what was pending for approval at the time. But of course, as we all know, and as we were just discussing before the meeting, Trudeau withdrew the invocation. He revoked the invocation essentially after it was pretty clear that there wasn't any pressing emergency that required the available resources of the act. And so, does anybody have anything to say about that before we put it into the drawer as come and gone? Howard?
Just there's supposed to be two inquiries or two investigations, if you will, into the invocation of the public order emergency. And so it's something we might want to watch as the PRC, one of which will be by a parliamentary committee. I don't know if it started off yet, but there was terrible wrangling between the official opposition and the government. The official opposition wanted the committee, the parliamentary committee, to be chaired by two co-chairs, both of whom would be conservative. You know, it seems like a kind of a silly argument going on, but at some point a parliamentary committee is a short-term investigation and it will get started. But the act also requires a longer-term investigation that would be hopefully by something outside of Parliament, hopefully under the Inquiries Act. So it's something I think we'll want to watch because they are extraordinary powers. The whole question initially is whether they were needed or not. I live in Ottawa, of course, although not downtown, so I was spared the worst of it. But even along Carling Street in front of my condo building, we'd see these caravans of truckers with their flags and honking their horns. I think it's easy to underestimate, and one shouldn't underestimate the pain and in fact torture that was visited upon people who live down in the market. There are lots of condominium buildings down there, multiple stories with a lot of older people. There's also convalescent homes down there, people who are dying of cancer, long-term care, people who couldn't get to their medical appointments for treatment of cancer, couldn't get their family to come and visit them while they were dying. It was a major event in Ottawa. And one ought to be asking the question, why did it last so long and what's going on? So anyway, I think we should watch for both of those inquiries. The second larger one has a larger time frame, but I'm hoping it will be more independent and not controlled, of course, by the government or by the official opposition. But again, Miles, just something to watch for. This statute, I remember when I first started to practice with the Department of Justice, the War Measures Act still existed. And at various times, as in-house counsel at what was then Solicitor General, I gave advice on both that and the Emergencies Act. And I know very well the lawyer, the justice lawyer, although the politician, his name is eluding me for the moment, who's taking credit as the architect. The actual architect was a justice lawyer, a general counsel of the Constitutional and Advisory Section, Henry Malott, and he did a very thoughtful job on this. it's easy to get into war stories, and I apologize. I remember being called on a Sunday afternoon by the Deputy Solicitor General. My wife had gone out shopping, and he had questions on the Emergencies Act. And I said, well, I'll do my best, but this was back in the days before we all had our personal computers and laptops. And I said, but I'd have to come into the office, and I'm watching my children. And the deputy said, oh, don't leave your children. I said, I'm not gonna, don't worry, I'm not gonna. But Henry Malad lives a couple of blocks away from me, so I called him and was able to get immediate, quick advice on the actual act. Tremendous lawyer, tremendous man. A lot of thoughtful work went into trying to make this a tailored piece of legislation that was limited by the charter, not overriding it, not going beyond it. But I'm looking forward to seeing the hopefully independent investigation or inquiry into its invocation, and of course some investigation of what went on within the Toronto Police, the Ottawa Police Service as well. So apologies for the long intervention, but it's a very interesting thing from a legal perspective.
Oh, absolutely. And so thanks, Howard. So we'll keep this on the agenda and watch it as it progresses through committee or those two particular committees. Really, really interesting thing, and this is a nice segue into the next issue on our agenda. The one thing that the Emergencies Act doesn't do, which the War Measures Act certainly did and was used by Pierre Trudeau at the time, was basically the suspension of habeas corpus. And that's something that is almost always used by governments when they invoke this kind of thing for the purposes of, for most part, things like domestic terrorism. So, for instance, Obama, who promised to close down Guantanamo in 2008, certainly didn't do that. And at Guantanamo, habeas corpus is suspended as well. So we'll touch on that in the next agenda, or the next item on the agenda. But it was really interesting when I read the act itself to see that in fact there was no reference to that in this particular piece of legislation, which simply means that the government, while it has a free-for-all for 7 days before there's any oversight, they don't have the authority to arrest people without a reason for that, and that reason to be justified in a court of law, which is what the removal of habeas corpus would do. Anyway, thanks again, Howard. We'll watch that, and let's move on to the next item, which is the habeas corpus guide launch. Howard, you may want to say a few things about that as well. You're the one that brought it to our attention.
Miles, I think Hank wanted to get in on the last discussion.
Oh, I'm sorry.
I pick up my paper this morning and find out that the convoy is heading our way here in Victoria, and they're going to stay for months. So I hope, this may seem a little harsh, but I hope none of the reviews inhibit the government in any way from exercising the same kind of response, should it be required here in British Columbia as they did in Ontario.
Yeah, thanks, Hank. That's totally understandable. Okay, all right. The item of the habeas corpus guide launch, interesting initiative in Ottawa. So, Howard, if you want to just touch base.
Well, this is something I saw, and I added it into the newsletter, which we try and make sure there's some interesting stuff in there from week to week. And I saw this and decided to include it because I've never seen anything quite like this before. Habeas corpus, as for those who aren't lawyers, but I think this is a very educated audience. It is one of the first tools that lawyers use to question the government's seizure and detention of individuals. And habeas corpus literally stands for to have the body. And so the writ calls on the government to justify its detention of an individual. And in the Emergencies Act context, particularly in the Pierre Trudeau FLQ crisis, which I remember, I wasn't in Ottawa at the time, but there were police officers and military officers with automatic weapons standing on every corner of the street. The Quebec government had gone into hiding, and FLQ members, a terrorist organization, had seized two individuals, one a diplomat, one a politician, and ultimately killed one, murdered one. And so Pierre Trudeau famously said, when asked, how far do you think you'll go? He said, just watch me. Large numbers of people were detained. Certainly anyone who's connected with the FLQ, but all sorts of other individuals were detained as well. And the habeas corpus was the prerogative writ that allows the lawyer to petition the court to demand that the government answer for its detention of the individual and release them if there are not sufficient grounds. Again, just the War Measures Act gave great sweeping powers to the government on that. And of course, it was developed prior to the charter. So the framers of the Emergencies Act, it was Perrin Beatty was the politician who actually was not a lawyer. He was Solicitor General for a while. At the time, he was Minister of National Defense, and when he introduced it. But it was designed specifically to be subordinate to the charter. So anything that would be regarded as a violation of charter rights could not be brought in under the Emergencies Act without meeting the Section 1 test and having court supervision of it. So anyway, the contrast between the two is interesting. The guide itself actually was designed not so much for emergencies or civil rights or demonstrations or things of that nature, but the guide was designed with its use for prison law in particular. And Matthew will know a fair bit about this. One of the ways of challenging various kinds of detention in a correctional facility is a writ of habeas corpus. But because someone who's sentenced and confined to a prison, usually there's a lot of cause and warrant and paperwork on it. The writ isn't that useful there unless someone has been kept longer than past warrant expiry. It's been used lately to challenge solitary confinement. So confinement within confinement. This guide is produced by some people at the University of Ottawa and other places. It has lawyers involved, but non-lawyers involved. And it's just a useful kind of primer on the basics. I love it has a section on when not to use habeas corpus or when habeas corpus doesn't apply. But it has become a remedy that's useful in the context of prison law. Although the recent invocation of the Emergencies Act and what's occurred in Ottawa, and I don't call it the truckers' protest, but the truck protest, because most truckers don't support it. But in various places in the country, whether it's Windsor, Ottawa, BC, Alberta, these issues are still live because there's a groundswell of people who are pissed off and don't know where to put that energy, if you pardon my Latin. But the habeas corpus application process was intended primarily for its relevance, this guide primarily for its relevance with respect to prison law. Let me invite Matthew to jump in on that. I know Matthew has a long history with advocacy for prisoners and may have something to add on that.
Oh, but I certainly appreciate the fact that you've got an updated guide. We had the Canadian Prison Law Association is fairly active in this area. We have a bunch of litigators who use the writ. They use it against involuntary transfers. I know Irving, as a former regional commissioner, knows what I'm talking about. It's used very actively on involuntary transfers. It's used sometimes on parole law and dangerous offender designations. And so it's still a very interesting kind of issue, and we're still experimenting with it. I have a client who's getting ready to file a writ pro per against his parole conditions, and he's on day parole in a halfway house, but he's going to be suing the parole board under a writ with respect to what he regards as unlawful parole restrictions. So it's a very interesting area of law. And thank God we still have the Supreme Court backing the general notion of a writ.
Yeah, thanks, Matthew. Thanks, Howard. The only other thing that it's used for, and this is a relatively common use for it, is when prisoners dispute their classification in prisons. You know, if they're putting into a maximum facility, then they believe they should be more often than not in a medium facility. It's used quite often in that context. But there we go. So thank you very much. Thank you, Howard, for bringing that to our attention. And a little Latin never hurts. Okay, so the next item is it's a note on the wrongful conviction of Nova Scotia man. I'll just give you a bit of a background on this, and then we can discuss it. This is a link that came from Lawyers Weekly. It was a three-part series by a young lady named Lisa Corrali. Lisa did this as a student editor for the Wrongful Conviction Law Review, to which I'm the editor-in-chief, and she's one of the student editors. So she wrote it up for the Law Review. It's, and remember, of course, it's a student effort, so it's not quite as perhaps polished as you would find in a scholarly journal, but we do have a student section in the Law Review. But she did a nice job with it, and obviously the Lawyers Weekly wanted to pick it up, and so with our permission, it was reproduced. It deals with the case of Glenn Assoon. He's one of the last, if not the last, exonerated person championed by Innocence Canada. So Innocence Canada took his case on. I was at the last Innocence Canada meeting, which I guess was 2019, and Glenn was there. He had just been exonerated. There's been a settlement with the Nova Scotia government for compensation. It's been closed. It's a closed settlement, so nobody knows what the terms of it are. But it should have been fairly substantial. He was incarcerated for a fairly long period of time, and primarily his exoneration was based on the fact that the Crown did not provide sufficient disclosure to a great degree. There was a lot of they had a lot of statements, witness statements, that they basically kept from him and his defense counsel for a very long period of time. Anyway, that's the nuts and bolts of Glenn Assoon's matter. Anybody have any other comments on it? No? Okay. Yeah, Hart?
Well, just to say that there are three parts to it. The first part we included in the newsletter with a link to the second and third part, and combined total, it's very informative because it looks not just at the particular case, but causes, recurring causes of wrongful conviction. And the student did a good job. Again, she's a student, not someone who's experienced in writing these kinds of things, but its length, if you take a look at all three parts of it, I think it's very, very helpful. So good on you, Miles. I think she did a good job.
Yeah, she did, and then we thank her for that, obviously. And again, she's now a second-year student at Ryerson Law, so she has one more year before practice, or before whatever Ryerson does to get you ready for practice. Yeah, the student board for the Wrongful Conviction Law Review is at Ryerson. So it's nice to have we have a dedicated team of 7 law students that do a really nice job for us. So it's a very nice synergy. Okay, next we have, and this is as a function of Brendan's efforts, we have a note and a link on the federal, provincial, and territorial meeting of ministers of justice and public safety, which was to a great degree a synopsis of criminal justice matters and a discussion along those lines. Brendan, you want to fill us in a bit on this?
I don't have too much to say except for I had skimmed it a little bit. I had shared it because I thought it might be of interest to the larger committee, but essentially, as you're saying, it's a series of items that are important to the criminal, at least to the ministers and whatnot, and could serve as an indicator of where criminal justice policy might be heading, or where we might want to concentrate our efforts. One thing that I thought was particularly interesting, at least for myself, if you all recall, I, along with the help from Howard and others, I had drafted a brief on a bill that was now no longer exists on rural crime and whatnot. But if you notice in that specific, the document that Miles is referring to, it does actually specifically mention rural crime as a priority. So at least personally, that reassures me of the importance that the bill, it assures me of the eventual importance of the bill. Like there are several other topics, but rather than go over them all today, I think it's just something interesting that I think we should all take the time to read a little more closely. That's about it for me.
Yeah, thanks, Brendan. We still have your the brief regarding rural crime as a waiting brief for the PRC, so it's still an item that we're actively watching. So this ties in nicely to that. So thank you very much. Any comments or, yes, Hart?
I'm sorry, I shouldn't be talking so much, particularly with my throat, but just the good catch for Brendan to notice that. He brought it to my attention, and I just want to add that these summaries of the FPT meetings are very carefully massaged. They have a lot of communication type language, and so they go through a process of negotiation. Irving can tell you this as well from the correctional context, and so there's a lot of input by communications people. So the content isn't as informative as the fact of what's on there. As Brendan had pointed out, it does indicate what's of concern. I was heartened to see the rural crime on, because I think it's an upcoming big issue that the justice system has not dealt with in any kind of a satisfactory way, recognizing that not everyone lives in an urban center. I think I said at one point that most of the policy people, most of the politicians, most of the lawyers, blah, 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 most of us live in urban areas, but we're missing vast parts of the country, including as we're focusing more on reserves and indigenous kinds of issues. But I believe it's an important upcoming issue. The communique highlights that they're preparing some kind of a framework, some kind of a way forward for a framework. The language in there makes me sometimes want to gag, because they talked about they've approved a way forward for a framework for something. I'm not quoting it exactly, but sometimes it's language to say, yeah, but it's on their agenda. And I think that's incredibly important. I think Brendan's brief will be relevant because I think that bill will be reintroduced by the Conservative member. But even if it's not, if this continues to get some communication profile in the FPT, in the ministers, in the political realm, then we could readjust that brief to speak to the issue directly, as opposed to any particular bill. So again, thanks, Brendan, for the catch and noticing it. They're important things to see.
Wonderful, thank you. All right, Brendan, thank you. All right, guys, next, other news and.
Miles, I think Lynn has her hand up. She's very polite. She's
oh yeah, little yellow, there you go. Yellow hand in the corner.
Thank you so much. I just wanted to second what you just mentioned, Howard, and also highlight that the review of the tragedy in Nova Scotia that's underway right now will likely highlight the issues surrounding policing in rural Canada. This came up a few years ago, you may remember, when there was a Aboriginal man killed in Saskatchewan by a farmer, and yeah, it was just a terrible situation, and a lot of opportunity for lessons learned into how to look at this more closely. And just as an aside, after the meeting, I would love to take a look at your brief that was written on the topic. That's an interesting area for me as well. Thank you.
Good point. Thank you, Lynn. Appreciate it. Anybody else? Watch for the yellow hand. Okay. All right. So other news and announcements. Again, this is a comment I will insert continuously. So please review the CCGA's newsletter on a weekly basis that Howard puts together, and to see if there's any news or issues to bring forward to the meeting that perhaps I haven't done that. So does anybody have any other news or announcements for today? All right, thank you. Okay, business arising. So we'll deal with the parliamentary committees. The first one is the Commons, Justice and Human Rights. Again, this is Howard.
Sometimes remember to unmute, but you should be happy that I'm muting. I'm clearing my throat every second here. But yep, Justice and Human Rights has been quite active. I mentioned last time that what's preoccupying Justice and Human Rights, or the Standing Committee at this point in time, is a review of what people refer to it in different ways. I refer to it C-36. It was C-36 introduced by the Harper government in response to a Supreme Court of Canada decision called Bedford that struck down the prostitution provisions of the criminal code. C-36 has a long title and a short title. The long title is an act to amend the criminal code in response to the Supreme Court of Canada decision in Attorney General of Canada versus Bedford, and to make consequential amendments. It also has a short title called the Protection of Communities and Exploited Persons Act. I noticed from the committee hearings that a lot of people have developed an acronym based on the short title. So they're calling it PCEPA or PCEPA, PCEPA. So you'll hear that reference to PCEPA and to C36. The committee has held 5 meetings so far this calendar year. As you recall, there was one in December where they elected a chair and co-chairs and all of that sort of business. Their first meeting in this year was February the 8th, which was in the afternoon of our last PRC meeting. So it occurred after our meeting. There have been 5 of those meetings so far and 28 witnesses called on PCEPA or PCEPA. And I'll get to that in a minute. Just before I go into that in any great length, I do want to say that in the February 8th meeting, the first part of that meeting was on committee business, and they approved the provisions and all. They approved the comprehensive review of C36, the PCEPA. They indicated that the committee will hold at least 6 meetings. So by my count, there should be at least 1 more left, and that they will table a report with the House of Commons, and they will request that the government table a comprehensive response to their report. Okay, so it's important to sort of bear this in mind. The C36 called for a review 5 years after it's coming to force. That should have occurred in 2019. It didn't. There's been some time lag. They've started it now. They're getting towards the end of their review. They will issue a report to the House, and they're calling on the House to respond to that report. The committees do not always ask the House of Commons to respond to the report. Sometimes they just table the report and the government looks at it and does whatever they want. But the committee has a bit of an edge to it here, saying we want the government, the executive, to respond to our review of C36. And so this will be sort of on the table for a while, and that's important. Now, before I get back to the C36 review, I just want to also say that on February the 8th, the committee also agreed to study, and I'm using their language here, the government's obligation to victims of crime, including the vacant position of the Federal Ombudsman of Victims of Crime and the review of the Canadian Victims' Bill of Rights. They've agreed that they will hold again at least 6 meetings on that topic. They will table a report with the House of Commons, and the committee requests that the government, i.e. the executive, table a comprehensive response to their report. So we're seeing a fair focus on victims' issues, including the Victims' Bill of Rights, which was again a Harper error piece of legislation, continues to be controversial in many respects. We did a brief some years ago on the Victims' Bill of Rights when it was first going to Parliament. We formed a subcommittee, and some of the members who were on that subcommittee are no longer come to PRC meetings, but there is a brief we did on it. I'm sure it's available somewhere. Maybe Irving can pull that out. But the Victims' Bill of Rights and whether it's had any real impact on protections of victims, victims' rights, et cetera, is an interesting question all on its own. So that's when the standing committee finishes its review of C36, that will be their next step. And it's something we'll want to take a look at and sort of compare it to our understanding of the Victims' Bill of Rights. I think the reference is also pointed in their terminology that they're also going to review the vacant position of the Federal Ombudsman of Victims of Crime. So they're nudging the executive again for not having replaced the Ombudsman. I hear from a variety of sources that the government is very slow in a number of things, including appointments. I won't put Lynn on the spot because she still works for the federal government, but it's what I hear is a lot of these things are delayed, and it just may be that the wheels turn slowly. But I think the committee is nudging the executive a little bit, saying we need an ombudsman. Why don't we have one? So that's something to pay attention to. Now, with respect, going back to the C36 or the PCEPA review, 28 witnesses, and it depends on how you count them. you may have observed that the notice of the meeting with the witnesses often differs from the actual witnesses who appear, which you will see in the evidence. So on the website, for those who haven't looked at it really closely, you can usually get the notice of the meeting. When it's ready, the minutes, which are very brief, but includes the official list of who appeared as witnesses, and then the evidence follows, which is a long transcript of what goes on. Sometimes there's a time lag, and Rob does a great job in following those on his report. But to tell you the truth, I just decided at some point that I didn't have the time or energy to read or watch the video of all 28 witnesses, and if I had, my report would take up this meeting and several others, so I spare you that. But they had a number of excellent witnesses, both groups and individuals, some of whom we know, some of whom we're not as familiar with unless you work in the area of sex trade law, sex trade policy, but some wonderful witnesses. I'm actually very impressed with many of them. My heart goes out to them. Many of them who've been sex trade workers or still are, and are now in advocacy groups. I'll give you just a little bit of a flavor for it, but some of the groups we know is Stella from Montreal, which is works for, advocates for, and is composed of sex trade workers or former sex trade workers. Pivot was there, the Pivot Law Society. I tend to call them legal services, but it's the Pivot Legal Society, which was a group, an excellent group that's its origin was in the Lower East Side in Montreal. So Hank may know something about that, but they're incredible in advocacy. Their work focuses on police accountability, drug policy, homelessness, and sex workers' rights. There was someone there, an incredible witness for the Canadian Alliance for Sex Work Law Reform, who was articulate, well-spoken. She was very impressive. There was another excellent witness, Alison Clancy, the executive director of SWAN, Vancouver Society. She talked at one point out in questions. They were in the last committee meeting on last Friday, talked about the fear mongering among the committee with respect to questions and responses by committee members about if the sex trade is legalized or decriminalized, Canada will become a haven. All the sex trade workers will come to Canada to apply their trade, or enormous numbers of young people will all of a sudden get into sex trade. And she talked about countering the fear mongering that was going on in the committee. These people are incredibly articulate, and their whole focus is the protection of people who work in the sex trade without the necessary moral judgment that those people shouldn't be there and ought to get out of it. So anyway, because there's so many witnesses and so much text, it seemed to me that what it's best to do is when the standing committee issues their report, I'll try and take a good look at that. I was hoping Stacey Hannum might join us, who's an expert in this area. Irving, did you get a chance to touch base with Stacey on this at all?
I wrote to her during our last PRC. I never got a response. And you haven't seen her name on the list of witnesses, presumably?
No, I thought she might be a witness, but she hasn't shown up yet, which doesn't mean that she won't. She appeared before that same committee when C-36 was going through. Right. I think she was the only CCJ witness who was able to give testimony to a parliamentary committee under the Harper era. She has incredible expertise in this area, so I am hesitant to say much because her expertise vastly exceeds mine on this. Hopefully at some point we can get her to chime in. Rather than go blow by blow with respect to the particular witnesses, when the report is available, we can chew on that because we can all take a look at that. But let me just also say that the first witnesses to appear were two Department of Justice lawyers. And I know them both. I have to tell you my own. Now, I can be hard. We can all be hard on the people we know. But I was disappointed by their testimony in a very significant way. in their defense, I have to say, and I know this only too well, as a justice lawyer owes his or her advice to the minister and to the executive government, whether it's legal advice or policy advice. So that advice goes to the minister. The minister decides whether or not to share it with Parliament. A parliamentary review ought to rely on their own research, their own evidence, and their own experts. So any justice lawyer has to be a bit circumspect with respect to it. But the committee, during the testimony of the one lawyer and during questions, they asked about research, about case law, about models of the sex trade in other countries, about whether SEPA is meeting its stated objectives, whether the Department of Justice had done any work in preparation for the parliamentary review, whether they had any advice, recommendations, or suggestions for the committee. In my humble opinion, the justice lawyer who was answering provided very, very high-level superficial statements about the research and the case law, saying that there was conflicting case law, saying that there was research done by Stats Canada, maybe the committee should call Stats Canada. When asked what they had done, if anything, in preparation for the 5-year review, which they've known about for 7-8 years now, since 2014, they had no answer. Of course, they couldn't provide advice, but one would have thought they had thought a little bit about where this review could go. And so, as someone who's appeared repeatedly for the Department of Justice on these kinds of issues, I was quite disappointed. If you read their statement, it's very brief. If you read the questions that were posed, there's a lot of sword work to deflect and not to really answer. And I was very disappointed that they missed an opportunity to help set this review on a good course. There were some good statements by that witness who said, among other things, that research that postdates C-36 concludes that the purchasing offense makes screening clients and negotiating safe transactions more difficult, and that the material benefit and procuring offenses prevent sex workers from working together cooperatively and assisting each other. So she indicated that the research supports that. She also said that they kept saying the matter is currently before the courts. She said that we see from the data that is available a very disproportionate number of Indigenous women and girls involved in the sex trade generally, which of course is important. And she referred to the Nordic model. Now, the Nordic model is what C-36 was based on, and it has been adopted by some of the Scandinavian countries. She said, and this is important, she said all Nordic approaches aim to end the sex trade. She was asked about whether this was a prohibitionist model. She said no, that the Nordic model posits that there's a power imbalance between the person who purchases and the person who provides sexual services, and that power imbalance is recognized by not using the criminal law against people who provide their own sexual services. In that sense, it's very different from a prohibitionist model. And so what she's referring to there is the fact that it's still illegal to procure or to buy sexual services, to advertise them, or for someone to live on the avail, so to speak. But the actual sex trade worker is given an exemption. Not that their behavior is legal, but they're given an exemption, a shield from prosecution. So again, the transaction is still illegal. People talk about an asymmetrical policy approach, and that's what this is, but it never says that prostitution is legal, and it's premised on the notion of eradicating the sex trade, which most of the groups that gave evidence find despicable. As they say, why would Canada succeed in doing something that no society since the beginning of time has been able to do? And they talk not just about prohibitionists, but they talk about eradication of the sex trade and eradication of sex trade workers. So they keep talking about the fact that the police and the government is trying to eradicate them. And they say that not all sex workers are exploited, not all of them are trafficked into the profession. Some engage in this activity willingly, and why should anyone be different? One of the witnesses talked about in any other profession, there's labor law, there's health law, there's all of this trapping of provincial regulation, none of which is applicable to sex trade workers. They talk about the fact that if a sex trade worker is renting an apartment and the landlord finds out, the landlord either kicks them out, raises the rent, or demands sexual services from them. The exploitation that's imposed on these people is enough to bring tears to my eyes, I suspect to other people as well. So many of the witnesses, for instance, Stella said, the entire PSEPA needs to be repealed. It is a law that is dangerous and that is harming people in many different ways. There is no legal ground. And she's the one who said all the protections that belong to all workers across Canada are not accessible to sex workers. That has very dire consequences on women we see every day. And she said this, and you've got to listen to her about the Quebec police. Not only are the Quebec police not, it's like the Quebec police never got to Bedford. Like they're treating it even as if the sex trade workers don't have immunity. They're exploiting them. It's unbelievable. She said, and two things. She said in Quebec, about 80% of women incarcerated in a provincial institution have sex work experience. They're often Indigenous women, transgendered women, and migrant women. These women are most often targeted by police officers and by abusers. And I want to emphasize this last line. Both groups, both the police and the abusers, have similar ways of targeting their victims. Boy, that just sends chills through me. There are other groups, the HIV Legal Network, the Asian and Migrant Sex Workers Support Network. So the notion that sex workers who are illegally in the country are particularly vulnerable, because if the police become involved in any way, right, they get deported, even if they have immunity from prosecution for selling their services. The vulnerability is so enormous, and as the witness from Stella said, both the police and predators know how to exploit that vulnerability.
Mr. Chairman, we are running out of time for the meeting.
Matthew, I will conclude my remarks by saying, and thank you for that. In the committee, they have these little cue cards, right? It says you have 2 minutes left or 30 seconds left. So we should get Matthew to get some cue cards and lift them up. So I apologize. I am going on it long. Thank you, Matthew. You're quite right. I think we want to watch the report. Even looking at a small number of the witnesses, again, is incredibly moving and heart-rending. Most of the witnesses are saying that PSEPA has to be repealed, which would take us back to the Bedford decision, which repealed all of the prostitution provisions. So you wonder kind of what's left. One other point I wanted to make just briefly before I concluded, but stay tuned. We should watch for this report. And the other thing I wanted to say was that a lot of committee members were asking questions they'd never allowed to ask in court. Not only were they misleading, not only were they leading questions, which is prohibited from examination in chief, but they were rhetorical questions. They were questions that presupposed the answer. And they were looking for sympathetic witnesses to make their point. And they still seem to be focusing on keeping C-36, but maybe tweaking it. So anyway, stay tuned. Thanks, Matthew. Sorry for going on at great length. Miles, my apologies.
No apologies necessary, Howard. It's exceptionally comprehensive, and we appreciate that. I just have one thing to add to it, so we're going to stay in this for a few seconds longer. On February 24th, the Ontario Court of Appeal struck down a Superior Court of Ontario decision that had basically ruled that Bill C-36, or Protection of Communities of Exploited Persons Act, was unconstitutional, along very much the same lines as Bedford did. Basically Section 7, the right to life, liberty, and security of person, was upheld at Superior Court level, as was the Charter of Freedom Rights to Expression and Assembly. Ontario Court of Appeal basically overruled the Superior Court of Ontario. So this is a very important decision. It's running in tandem, obviously, with the committee work. And what the Ontario Court of Appeal did, however, instead of basically reversing the Superior Court and reinstituting, you're basically putting a conviction in place, it basically ordered a new trial. Having said that, You know, the respondent in the appeal has every right, of course, to seek leave to the Supreme Court to basically uphold the High Court decision, Superior Court decision. So we'll see what happens. But you know, all this took place since our last meeting, so I thought we should bring it to the attention of the committee. It's dealing with this very issue. So we'll keep track of both the committee work that Howard is so comprehensively doing, and keep an eye on this decision and see what happens. Because and I mentioned this at our last meeting, you know, it was totally expected after Bill C-36 was enacted that someone would be charged, you know, under what then became the new provisions, which has happened, and it takes 7 years to make it to the Supreme Court, and so the time frame is about right. So let's pay attention to that. Howard?
Well, it's just and it's ironic to me that that's something I wanted to cover, and I missed that part of it, the law. I have the M period, S period, the Ontario Court of Appeal decision. So maybe I'll send that to you, Miles, and to Peter, so you can add it or add a link to it. It's a long decision, 27 some odd pages. There's no real conclusion, but it overturns, as you said, the trial decision that struck down all three: procuring, advertising, and I forget that they're living off the avails. There is a case in Alberta that also struck down parts of C-36 and is on its way to the Alberta Court of Appeal. And in addition to that, one of the groups present, one of their very impressive groups present during the period, I'm just flipping through, has launched a class action as well. So Miles, right, of course, this is going to end up going to the Supreme Court of Canada, but there are a number of ways in which it might go up. The witnesses on Friday talked about the Ontario Court of Appeal decision and indicated that the Ontario Court of Appeal was basing their decision on a hypothetical that has no reality, that in fact doesn't make a whole lot of sense. So we'll have to see that the courts are not finished, but the Canadian Alliance for Sex Work Law Reform is part of a challenge and has been an intervener in the Ontario case and others. So we will see more litigation appellate on this, something coming from the Alberta Court of Appeal probably in the next few months as well. So thank you, Miles. I'd forgotten to address that part of the issue.
Okay, good. Thank you, everybody. Okay, let's move on to the next committee report. This is the Commons Public Safety and National Security. Rob, do you have anything to report to us?
Yep, I do. There were 4 meetings, February 17th, 25th, and then March 1st and 3rd. On the 17th, they resumed their study on gun control, illegal arms trafficking, and the increase in gun crimes committed by members of street gangs. And they decided they had to allocate a small budget to the study of crowdfunding platforms and extremist financing. On the 25th, they moved on to studying the occupation of Ottawa and the federal government's response to the convoy blockades. So that was a lengthy meeting with CBSA, the Department of Public Safety, RCMP, Department of Finance, Department of Justice, and FinTrack. So they covered the full range of the main parties I guess you'd expect to be there. There was some discussion, let's say, on the point of having the act, like what it was designed to do, and also, of course, whether it was needed. So some testimony and whatnot on that issue. As Howard mentioned earlier, there was going to be 2 reviews. The first one is a joint committee of parliamentarians to be struck to review the declaration of the emergency itself. And then the second one is followed by it'll be followed by an inquiry into the circumstances that led to the act being invoked. So those are your 2 reviews, and that was a rather interesting meeting, actually. I'll leave it there. If anybody has any questions on the details, they can feel free to get in touch with me later. But a lot of this stuff was, in the news, what the thing was designed to do, and the trouble that people had with it. There was one comment on there that was interesting. I think it was made in relation to the finance part of that whole thing, crowdfunding and whatnot. So this line of talk was around whether new things were needed to deal with the problems. And the response was not that there weren't existing, it's not that there weren't existing statutes to deal with much of this stuff. It's that there weren't existing statutes to deal with it effectively. I just thought that was a kind of an interesting way to put it, and perhaps there's some truth in that. Anyway, reviews will be done and we'll see where that takes us. March 1st, they resumed the study of gun control, had government departments there, no evidence available today. And on March 3rd, they commenced a study on crowdfunding platforms and extremist financing with GoFundMe, PayPal, and Stripe providing testimony. And again, no evidence there as of today. Perhaps the most interesting or important of all of this is the latest issue with Russia and what's going on with Ukraine. So a motion was put forward at committee and agreed to immediately begin a study on Canada's emergency preparation for the range of threats posed by Russia, in particular national security, critical infrastructure, espionage, sabotage. I'm just going on here, weapons of mass destruction, and of course, Russian misinformation. So it was further agreed that to report the findings to the House on that, and to ask the government to table a comprehensive response to the report. So there'll be some work done on that important issue. And that's all I have. Thank you very much, Miles.
Thanks very much, Rob. Any questions or comments for Rob? All right, thanks again. Okay, next we have the Senate Legal and Constitutional Affairs Committee. Brendan, you're up.
Yes, so the committee met twice since our last meeting. They actually met the day after our previous meeting. They've continued to study the same bill. It's a Senate Bill 210. If any of you recall from the last update, the short title is Protecting Young Persons from Exposure to Pornography Act. There still seems to be quite a bit of debate going on. There's been various witnesses called. And I should mention, while I've read the transcripts for the February 9th meeting, there was also a meeting on March 2nd. I admit I was holding out to see if the transcript would come out before this meeting. It wasn't, so I was trying to follow the video. So I have a little less information on the March 2nd meeting than the February 9th, but similar information, similar discussions were had at both meetings. Essentially, the major points in this with this bill is that if you recall, the senator is trying to restrict people under the age of 18 from being able to consume pornography online. The premise being, well, they can't get it in person, so we should also try to prohibit that online as well. The main mechanism for doing so is forcing internet service providers or websites to institute age verification technologies. What those technologies are not specified. It's left quite broad. The senator who is sponsoring it is quite adamant, from what I've seen, that right now they're trying to put in a general framework rather than to put in specific technologies into the bill, given how quickly technology changes. With that said, several senators and witnesses that have had concerns, given that no technologies are specified. There's a lot of things up in the air about what types of technologies would they use. Would they use facial recognition technology? Would they use other biometrics? Would they use other ways of confirming identity through third parties, whether it be through a bank account, having a credit card, et cetera, et cetera. There are significant privacy concerns that are being raised with that. There's also concerns raised by various witnesses. I should mention that they've had witnesses from academia, they've had lawyers testify, they have had someone from the CRTC. In the latest meeting, actually, they invited a witness from a German state who has had similar laws on the books since 2003, explaining their experience. Nevertheless, like I said, there's significant privacy concerns. There are concerns that the wording of the bill are overly broad. So, for example, while the senator who has sponsored this bill is thinking of traditional, like large free pornography websites, others have pointed out that you can you can see pornography on Google, you can see it on Twitter and Reddit and things like that. So they've rightfully, in my opinion, raised questions about, well, how would you have someone confirm their identity before they use Twitter or things like that? So I know there's not much time left, but generally there's a lot of questions about privacy and not truly being able to monitor the collection, storage, and sharing of personal data. There are concerns about the bill being overly broad. There's also questions about the need for such government intervention when it comes to matters of pornography and things like that. And also there's significant concern about who would actually enforce these. One thing that I will just add that might be of interest to the PRC is that there are sanctions for not instituting these age verification technologies. They have a administrative pathway where it's more of an administrative penalty and whatnot, but they also have proposed criminal sanctions of about $250,000, I believe, for an entity for allowing a young person to gain access to pornography. So that's one thing. It's being discussed. It's something that I think the PRC might want to keep an eye out for, just if they do try to use criminal sanctions as a deterrent. And I will leave it there. Again, it's 1 o'clock, so I'll just leave it there.
Good job, Brendan. Thank you. Any questions or comments for Brendan? Okay. And lastly, on business arising, the Senate Human Rights Committee, that's mine. They've only met once since our last meeting. They're still dealing after second reading in the committee with the Bill S-211, which deals with the forcing of child labor and the goods produced as a function of that. And there's nothing new to report in that regard other than the committee meeting. And we decided last month that we wouldn't be following this bill in any event because it's really not a particularly justice-related enactment. Okay, so it is 1 o'clock, so we're going to have somewhat of an accelerated remainder of our agenda. And I apologize if I miss anything. Hopefully I don't. Items B, C, D, E, and F are all waiting briefs, so we don't need to discuss any of those unless somebody has a point to be made. G, invitation letter for consultation on facial recognition guidance. Peter and Lynn are working on that. So do you have anything for our edification?
Just a quick thing, if I can jump in here, Miles. Lynn and I have met twice, actually 3 times, including this morning, working on this. We have a draft actually looking quite good. The response has got 10 questions in it, and we've addressed all 10 of them. What I'm proposing, and I did say I'd have something to you for this meeting, my bad, I'm under the bus, but anyways, it's coming. What I'd like to suggest is that because the issue is not quite just as simple as restricting police on their use of facial recognition technology, it has much broader applications, and it's actually very similar in some respects to the issue between CSIS and the RCMP and information sharing when it can and cannot be done under the acts. Respective acts and that whole process. So there's a little nuance coming in here. What we'd like to do is we'll finish off with our draft, send it to you, Miles, to send out to the PRC, and we would request the PRC then look at that and return to us individual comments, either in terms of wordsmithing or content. For or against. It's not a matter of we will incorporate those responses into the final draft outlining, and especially if there's a disagreement, then we will incorporate that as well, obviously properly stated. So then that can now come back to for a final kick at the can by the PRC, and then deciding where it should go from there. Actually, I would suggest it does go back to the Office of the Privacy Commissioner. And I'll be quiet there. Lynn, do you have anything else to add? Or have you gone? I think Lynn's gone.
Oh, no, Lynn's here.
Lynn's there, sorry, didn't see you, Lynn. Anything else to add?
Sorry, I actually got kicked off, so I'm just going to stay quiet and listen to our colleagues if they have anything to add. Thank you.
Thanks, Lynn. Thanks, Peter. Any comments or questions, Peter? All right, thank you. Okay. Next item on the agenda is the item H, invitation to participate in a national consultation on human trafficking. Irving spoke to this last day, and I believe you were going to be turning it over to John.
John's got it. I think he was already involved to some degree. I have not heard anything new from him though.
Okay, we'll leave it as it is then, and we'll see if there's anything more next meeting. Next item, alternatives to incarceration. This has become a very broad topic for our discussion. The genesis of it was Matthew, and so Matthew and Kyle and Irving, you guys were coordinating efforts to bring this thing forward. So anything for our purposes today?
Well, we've been negligent on this. This was in response to the mandate letters for both, particularly for the Department of Public Safety and to a lesser extent, the Department of Justice. And we were kind of intrigued as to why there was no reference to alternatives to incarceration and prison reduction. But we have not yet put together a letter. The history of CCJA going back to 1919 is replete with this kind of material and issues that were brought forward, including the historic opposition of CCJA to capital punishment from the very beginning. So I guess I better get off my horse and get to work.
Thanks, Matthew. Okay, Kyle's not here. Irving, do you want to add to that?
No, I have nothing to add, but I'd be prepared to do whatever wordsmithing and sanding of the corners once Matthews gives me something.
That's great. Yeah, okay, we'll come back to this next month then, so it stays on the agenda. New business, we don't have any new business. We talked about that previously. So let's deal with the bills. We won't deal with those that basically have no changes since the last meeting. But we do have no change on Bill C5. This is what Howard was dealing with. I did send Howard a dated article on conditional sentencing I wrote quite a while ago. It's now appended there for everybody's review, just to give everybody a background on how conditional sentencing came into being. And how the government and courts dealt with its enactment and its utility over the years, and how its utility was diminished, in a relatively short order. Howard, do you have anything to add on this, on Bill C5?
No, just that work's ongoing. I want to say that we've been very fortunate to have Brendan Johnson join my little team, and Brendan's providing some invaluable addition. He's bringing the criminological evidence side to it. I've got my two pro bono law student, Canada law students working on some of the legal analysis. January, February has been very hard on everyone, and students attending remote learning at law school are having a difficult time. I have to note that one of my pro bono law student, Canada law students, gave birth to a very healthy baby boy on February the 24th. So that, I think that takes priority. But anyway, we're working away, Brendan, Naomi, Claire, and myself, and we hope to have a good brief ready for the next meeting. This bill hasn't moved very quickly. It hasn't moved past the beginning of second reading, which started last year. It's had no airtime this year. And of course, Parliament's recessed this week and next week. So anyway, we're hoping that at the next meeting, we'll have a good draft brief, and that will be in good time to suit the process. And Brendan's been just fabulous. So thanks to Brendan.
Thanks, Howard.
Wonderful, thanks, Howard. Thank you, Brendan. Okay, all right, so just quickly, Bill C9, government bill, there's been no change. Regarding the Commons private member bills, C202, no change, C216, C220, C229, and C230, no changes there from our last meeting. Bill C233, which I've recorded as a first reading on February the 7th, which I think I missed last month, my apologies. basically deals with amending the criminal codes to require a justice before making a release order with respect to an offense dealing with a intimate partner to consider if it's desirable in the interest of the safety and security of anybody to include as a condition of that order that the accused wear an electronic monitoring device. Okay, that's pretty straightforward. Again, it's had first reading, and that's where it is at this point. It hasn't progressed to second reading. Bill C-250 had first reading February the 9th. It's to prohibit the communication of statements other than in private conversation that willfully promote anti-Semitism by condoning, denying, or downplaying the Holocaust. Pretty straightforward. Bill C-257, first reading on March the 3rd, seeks to add political belief and political activity as a list of prohibited grounds under the Canadian Human Rights Act, which everybody knows affects those who work in the federal sector for the most part. Okay, so moving to the Senate, we have one government bill for the Senate, Bill S-4, which is let's see, first reading February the 8th, so same day as our last meeting, and the enactment is there. The purpose of the enactment is there for you. Deals to a great degree, use of electronics as a means of jury selection processes and remote appearances for accused and offenders, etc. Replace tele-warrant provisions that permit a variety of search warrants, authorizations, and what have you by way of telecommunications. So it's a modernization to a great degree of communication in the justice system. So again, it just had first reading. It'll move on to a second in committee, and we can report back on it. And that just leaves us with private member bills for today. So we have Bill S-206, which is now in second reading. It deals with the prohibition against the disclosure of information relating to jury proceedings, with the exception of care provided by healthcare professionals. So that's been burning for a while, and so is the second reading. So obviously that is a empathetic kind of enactment to allow those who serve in juries who have been obviously affected by those proceedings to get care and to have the ability to relay the content of the jury deliberations, I would think, during that any meetings relating to that care. Okay, Bill S-212, there's no change. Bill S-213, its second reading is in progress. It's amends the criminal code to give the court discretion to vary punishment to be imposed on an offense. It's very broad. It's basically saying that judges, are to have discretion in sentencing, no matter what the provision, says in the code, which I would think is directed towards mandatory minimums to a great degree. So that's a very broad enactment. That would have been a really nice the first Commons bill that Trudeau introduced, in 2015, as in we now rescind all those mandatory minimums that the Harper era put in place. But having said that, it's a private bill. It's in the Senate. We'll see what happens to it. Again, it's at second reading. Bill S-224, it's likewise a second reading, and this is an enactment to amend the code to specify what constitutes exploitation for the purposes of establishing whether there's been trafficking in persons. Okay. S-230, no change. S-231, it's a second reading, basically, and it's a bill to expand the collection of DNA for various charges. So that's ongoing. S-238, likewise, the second reading, and this is to provide to amend the code to provide for the possibility of ordering an accused, defendant, offender, or other person to refrain from publishing, distributing, transmitting, or making available on the internet any information concerning victims. All right, and it also amends the Canadian Victims Bill of Rights. Bill S-229, first reading was March the 1st, and it quite simply wants to reduce the criminal rate of interest from 60% to the Bank of Canada's overnight rate plus 20, which is going to have a lot of payday providers up in arms, I would think. And finally, we have Bill S 232, likewise a second reading. And this is an enactment that provides for the development of a national strategy to decriminalize civil possession of illegal substances, which is a concerted effort to go beyond the obviously the decriminalization of pot possession into other types of drugs for personal use. So that was a quick and dirty review of legislation. Any questions or comments about any of that that I unfortunately skimmed far too quickly over? All right, well, that's it. Okay, so that's not too bad. So our next meeting is Tuesday, the 12th of April. We'll get the agenda and the minutes out to you in an appropriate period of time. Thank you, everybody, for today's meeting. Much appreciated. As
Thank you,
always,
Miles.
incredibly informative.
Thanks very much.
Everybody,
Everybody,
have a nice month, everyone.
take care.
Bye. All the
Thank you.
best.